courts, it can be classified as jurisdictions. Jurisdictions. So these jurisdictions are, if we talk about Supreme Courts, jurisdictions. If I say this, so it can be classified as number 1, the original jurisdiction, then comes appellate jurisdiction, then comes advisory jurisdiction, and then comes writ jurisdiction. Original jurisdiction means power of a court where a case can originate. First hearing done. Session courts are having original jurisdiction in matters of a case covering death penalty, death sentence. High courts have original jurisdiction in matters of various laws, special laws, where direct case should come to high court, like company law of India provides for certain cases to be originating in high courts. As far as Supreme Court is concerned, the original jurisdiction is related to disputes between disputes between union, state or states. So union as one party, another state as one party. Union as one party, so many states, 2 or more states as other party. And it can be union and one state and other states as party. So union and states, number 1. Union plus states versus state/states as other party. And number 3, state/states versus state/states. Okay. So that it's a kind of, you can say, federal disputes. When does the Supreme Court enjoy original power? Federal dispute. Okay, so it's original jurisdiction. Now appellate jurisdiction of Supreme Court. So in civil matters, in criminal matters, civil matters, when can Supreme Court hear appeals first? Civil matters, number one, when High Court gives a certificate. Means High Court says to Supreme Court, please hear. When High Court will say? When there are matters concerning two or more states, or it carries certain substantive question of law or constitution to be interpreted by Supreme Court. So a substantive certificate is given by High Court when a substantive question of law or constitution to be interpreted by SC. This is belief of the High Court that there is some law related matter, some substantive matter of law, which it is better Supreme Court should interpret. Or there is some matter of constitution which Supreme Court should interpret. In that case, High Court can give certificate, okay, you go, take appeal. When High Court has written, then Supreme Court will have to hear. Same thing is applicable in this case, High Court certificate, in criminal matters also. If High Court suppose does not certify, if High Court certifies, then Supreme Court have to hear, because High Court has said appeal will lie. Supreme Court cannot say no. Supreme Court will give date that we will hear. But High Court has not written, High Court has not given certificate. Can Supreme Court hear appeal? Yes, Supreme Court can hear appeal. This is because of some special power of Supreme Court. It's called special power of Supreme Court. It is done through SLP. It's called special leave petition. An SLP is filed. SLP can be admitted. There are process like some judgment is given within 30 days. In many cases, 30 days time frame within which SLP must be filed. So if special leave petition is filed in Supreme Court, then Supreme Court will decide, will I hear? Will I not hear? That is jurisdiction of the court to say yes or no. Right of the person who is appealing is not existing. Here High Court when issues, it's a kind of right. SLP is given, it is no right. Right to hearing is not there, not right, no right. Supreme Court's willingness, yes or no. And this is equally applicable in case of SLP. In case of, criminal matter, special power. Means in civil and criminal matters, either High Court certifies, Supreme Court will hear, or Supreme Court itself accept SLP, it can hear. But in criminal matters, it is right of the person. Here no right. High Court gives certificate, right of the person. SLP no right. But there is third case where right is existing. This is related to death penalty. And death penalty in two cases. A person has been awarded death penalty by High Court. Then appeal will lie in Supreme Court. In two cases. Case number 1. High Court reversed the judgment of subordinate court. Means subordinate court acquitted and High Court given death penalty. It's a very serious matter. Then Supreme Court must hear. And number 2, High Court takes to itself the case from subordinate court. So means subordinate court is hearing, High Court says give it to me, I'll hear. High Court took to itself. In these two cases, and High Court awarded death penalty. So High Court reversed the judgment and awarded death penalty. When subordinate court acquitted, High Court given death penalty. And subordinate court is hearing, High Court takes to itself and give death penalty. In two cases, the convicted person, the person who has given death penalty, he can approach Supreme Court as a matter of right. So it's a right of the person. Supreme Court must hear this case. Otherwise, in civil and criminal matters, the appeals power to appeal are similar, or you can say same, it is there. What the point? It's appellate power, means any decision of the High Court civil matter, Supreme Court will hear. Any decision of the High Court criminal matter, Supreme Court will hear. These 2 way in civil matters and this 3 way in criminal matters. Clear? So it is the appellate jurisdiction. Then comes advisory jurisdiction. So advisory power in Indian Constitution, we have Article 143. Article 143. Executives can take advice from Supreme Court. That means President can take advice from Supreme Court. On a question of law or matter of interpretation of Constitution, on an important question, on an important question of law or interpreting Constitution or interpreting Constitution. This is called presidential reference. This for this purpose advisory power is called presidential. Now here Supreme Court can say I will not advise. Here one feature here, SC can deny giving advice. One part. Number two, government is not bound by the advice. Government can act otherwise. Government is not bound by advice. When Supreme Court has given some advice, do this way. Government does not do that way. Then you can ask that, then what is the significance? It is basically government has various issues to understand the dynamics of law, and Supreme Court can help government out as a kind of legal advisory given to government by Supreme Court. So government when fell into some complexity of law, Supreme Court can bail it out. This is the significance. So it is advisory jurisdiction of Supreme Court of India. And fourth one is writ jurisdiction. Fourth one is writ jurisdiction. So writ means special orders. It is available to court as per Article 32 for matters of fundamental right, when fundamental right is violated, abridged, infringed, then common man can directly approach Supreme Court. There is no requirement to go to lower level courts. Therefore, writ jurisdiction is also an original jurisdiction, a type of original jurisdiction. It's always studied as separate head. And in this case, 5 writs can be issued. These writs are habeas corpus, to have the body, mandamus, to command, prohibition, to prevent a court from taking a matter which is not under its jurisdiction, certiorari, to quash a judgment given by a court if the subordinate court is not having jurisdiction to try that matter, and quo warranto. By what warrant or procedure? Means a person is having acquired a public post, but he does not deserve that post. Law does not provide for his post position. Law is ignored to give him post. Rules, regulations violated to give him post. Quo warranto. That you study in general studies extensively, you have knowledge. To have the body, to command, to prevent a court from taking a case which does not fall in its jurisdiction, to quash a judgment of the court which does not fall in their jurisdiction, and to ask a person who is occupying a public post without due procedure, without due norms, law, rules, to by what warrant or procedure. So these are 5 writs issued by court in matters of fundamental right. Our constitution also provides that apart from fundamental right, when fundamental right is not violated, but other matters of law are in question and violated, in that matter also writs can be issued by court. So these writs, I think you can verify 139, article 139, writs other than issued other than for fundamental rights. So here fundamental right violated, court cannot say no. Court must issue writ. Court must hear petition. But in other matters, it's court's discretion. So court has power to issue writs. Supreme Court, High Court also. High Court has power for fundamental right under Article 226. For other matters also, court have power to issue writs. Okay, so it's called writ jurisdiction. The 4 types of jurisdiction court has, and based on this jurisdiction, Indian court system function. Okay, so I'm not giving writing here. Why? Because these are more and more factual understanding. It will give you understanding of the judicial system functioning. Questions are not asked this way. Questions are asked from issue areas, from the significance part of law, independence of judiciary, judicial activism, related concepts and phenomena. The questions are asked from that part. So from that context, when I'll be giving you writing. These are the knowledge enhancement related, but the base and foundation of your knowledge concerning judicial system I shared with you. These things you can apply when you are writing. Got the point? So we have covered in this lecture, in this proper lecture, we covered about the why judiciary exist, when judiciary intervene, what are the tools, mechanism and power. Here we discuss the structure of the judiciary also, its powers including structure of Indian judicial system, and these 3 topics I'll take in the next lecture. It's very important topic because it's the question area from where the question is asked. Okay, so do it properly, revise it, have your notes, what I am saying or what I have written, that make notes of that. Based on that you revise it more. It will help you in GS paper 2 especially. Okay, and I'll take up the next topic, other topics, important topics, significant part in my next lecture. Clear? Thank you very much.